For over a decade, LawPay has been the gold standard in legal payments, giving law firms the ability to easily and securely accept credit, debit, and e-check payments anytime from anywhere. Visit lawpay.com/DCBar to schedule a personalized demo of the leading online payment solution for the legal industry and see for yourself why the DC Bar chose LawPay as a member benefit partner. MyCase is a top-rated end-to-end legal case management software that helps firms run efficiently from anywhere, provide exceptional client experience, and easily track firm performance. Streamline day-to-day firm processes in one easy-to-adopt solution. Lead tracking, client intake, case management, e-signature, billing payments, and more. DC Bar members are eligible for a 10% lifetime discount. Start your free trial, no credit card required, today.
Welcome, everybody. This is Brief Encounters, and I'm Federico Varias, Senior Program Attorney at the DC Bar. And today, I'm excited to be joined by my good friend and former law school classmate, Eric Perot, who is an expert trademark lawyer. And so I'll let him introduce himself a little.
Hi, Federico. Thank you. My name is Eric Perot. I'm with Gerben Perot in Washington, D.C. We primarily do trademark and copyright law, and particularly we file and what we call prosecute a lot of trademark applications. So typically we'll do about over 1,000 a year on average. And so I see a lot of trademark applications and a lot of different problems that come up with trying to register and protect trademarks. And that's primarily what my practice looks like.
So I invited you to talk to us last week because I saw you posted something really interesting on LinkedIn about trademark expungements and reexaminations. And you had a story about that. And I thought it was pretty interesting. So tell us a little bit about what's going on in this space.
Sure. So starting in December of 2021, the U.S. Patent and Trademark Office launched new proceedings called expungement and reexamination. For the most part, they're the same thing. There's a few little things here and there, but what they represent is the biggest change to the trademark procedures that we've seen in at least a decade, possibly more. And what they are is a new streamlined proceeding that allows pretty much anyone, and that's something we'll talk about, is that there's no kind of standing requirement or anything like that. But what it allows is for third parties to go to the Patent and Trademark Office and say, I did an investigation, and it looks like this trademark registrant was not using this trademark on the goods and services that they said that they were when they filed this application. And I want them to be removed. And that might sound like a pretty small thing, but if you think about it, the trademark system is something that is it's one of the best in the world. I mean, I'm a little biased because I'm a U.S. attorney, but it is one of the most sought after things for brand owners around the world is a U.S. trademark registration, because it gives all these additional rights. It gives recognition that this is an exclusive right to use this phrase by the U.S. government. And so everyone's looking to get that. And we've got more and more filings every year. And now we have a way of saying, well, what if this person wasn't telling the truth or did not properly say that they were using this brand when they said they were, and they're kind of taking up space on this register that they shouldn't. And so now we have a way to deal with that in a streamlined way versus before, which you'd have to essentially do administrative litigation in order to get it removed. Now there is a new system that we're able to use to kind of go after that deadwood, what we would call it, on the register.
And why would people register a trademark they're not using?
Yeah, I mean, there's a lot of ways, but you think about, so when you have a trademark registration, you're presumed to own it on anything that is listed in that registration. So if I sell sunglasses, I could also list anything else in that class. So sunglasses are in class 9. So is computer software. So is computer hardware, different kind of mechanical hardware, things like that. And so what we see is someone who files and might want some kind of rights for a specific good, but might file for things that they aren't supposed to or that they're not actually selling, to try to get broader rights than they actually are entitled to. And we most frequently see this with international filers. Different trademark systems in other countries do not require use when you file. The US is somewhat unique in that compared to other jurisdictions. So what we typically see are international filers who are filing in the US and perhaps seeking rights that they're broader than they should be seeking, and ultimately taking up space on the register that they're not entitled to. And I think that's what these proceedings are particularly designed to address.
Interesting. So this is part of a Modernization Act, right, on trademarks. What else changed on the act? Is there anything else that
Yeah.
like why did this happen?
Sure.
This is my
So,
question.
so there's a few reasons why this happened. One is overdue. There's a few things that they did address, kind of that have been around of complaints that the trademark bar and trademark holders have had for some years. But I would say about 3 or 4 years ago, the U.S. Patent and Trademark Office began to see that there was this concept of deadwood, that there was a lot of trademark applications out there, and it wasn't really clear whether they were in use and whether they should still be valid. And what they did is they did a pilot program, and they said, okay, we're going to audit trademark registrations that where someone said 5 years after or 6 years after they applied and they registered it, they said, okay, I want to renew this trademark for these goods. I'm still selling each one of these goods and services that are listed. Well, they audited those registrations and found more than 50% of them contained goods that the trademark owner could not substantiate with additional pictures or proof that they were actually selling these items. And so that was the first thing that tipped them off that maybe there's a problem here. After that, we started seeing an influx in mostly registrations from China, that there were some suspicious kind of indicators on them. The specimens tended to look, and a specimen is the photo that you provide to the US Patent and Trademark Office as an example of how it's being used in commerce. Well, some of these were doctored. I was doing research for an article, and it was actually the subject of the petition that I ended up actually filing shortly after we were able to file an expungement. But in 2018, I recognized that an image looked suspicious to me. I ran it through a reverse image search and found out that it was available on Getty Images, and that the trademark applicant had simply added a tag to it. And I looked at it and thought, well, this is, that's ridiculous. And me as an attorney with no interest in this, I had no standing to do anything about it. I told the PTO and they said, well, look into it. And then now that is a registered trademark. And that was the start of a problem that has been creeping up and has exploded in the last year and a half to 2 years. And that they even gave a nickname to that they call it the surge. And what we're looking at is a massive increase in trademark application filings, some from US companies, but mostly this kind of surge is from Chinese applicants. And they file in a very similar way. There is a formula to it that many of us find suspicious, in so much as they always apply for about 10 to 15 items in one class for goods. And typically the specimens they submit look suspicious. They're not like, someone who normally would have like a picture of their product sitting on their desk. It always looks like these are being sold in kind of a marketplace that you've never heard of, or in a way that looks suspicious. And until now, there was really nothing as a third party you could do about that. If you do have a concern that your trademark will be denied or damaged by one of those kind of applications or registrations, if it registered, you can file to cancel it. That's that kind of administrative litigation we talked about, the Trademark Trial and Appeal Board. You could have done that. It costs $600 per class, and suddenly you are running litigation against another party. It could go to default judgment, but ultimately, that's the concern that we have. And so that was kind of the second thing, or these kind of influx of new filings. And when Congress started looking at this, they went to the PTO, they went to stakeholders. I was able to be in some of the roundtables early on asking, well, what can we do to improve the trademark system? And universally, we all complained about that there's no way to get rid of these applications that look very suspicious. And they said, okay, well, we'll look into it. And since then, the examination time to review a trademark application 2 years ago was about 3.5 to 4 months. That's when an examining attorney with the US Patent and Trademark Office would look over a trademark and say, yeah, here's the problems I have with it, or they approve it. And that usually would take about 3 to 4 months. We are now at about 8 months. And that is significantly causing problems for US brand owners or for potential trademark applicants because they need to make business decisions. And now they are stuck in this hole where they're not even going to hear from the PTO for at least 8 months. And they hired more examining attorneys. We're hopeful that number will go down. But that's kind of the background of why the Trademark Modernization Act was passed. And that's a long answer to your question of what's in the Trademark Modernization Act, but there is two parts to it. So the biggest things are expungement and reexamination. That went into effect in December 2021. The other part is shorter deadlines. So now instead of a 6-month deadline to respond to a USPTO office action, there can be shorter ones. Right now, the active rulemaking that's out there is that it's likely to be 3 months instead of 6 months. And that'll speed everything up a little bit as well, because people won't be waiting for other ones to kind of process. It'll speed things up a little bit. The other one is irreparable harm. So essentially, they said that there's a presumption of irreparable harm. It's a little bit of a technical thing that really trademark owners and brand owners really pay attention to with litigation. But when it comes to kind of the biggest procedural change, it is definitely in expungement and reexamination, which just went live recently and gives us these new tools.
So I want us to talk about expungement and reexamination. I want to know, like, are they different? Are they the same thing? And what you would use them for? But you have to tell us your story about filing one of these.
Oh, right. That's burying the lead. Yeah. So I was doing this research back in 2018, found this specimen that clear as day was a stock image that someone had added a tag to, got registered. I wrote an article, got the article published, moved on, and started getting involved with the Trademark Modernization Act, or what would become the Trademark Modernization Act from a policy standpoint. Then when we found out when petitions would be going live, I thought, well, I don't have any clients that I would at least publicly say, hey, I'm going to file this and we're going to be the first ones to do this. I'm not going to spend the client's time and money on something that's so unproven at this point. I should just file one, because one of the biggest things, and I briefly mentioned this, is that there is no standing requirement. When you file litigation, or if you file administrative litigation, you at least need to have standing, whether that is you believe you're going to be harmed in some way or something like that. It can't just be that you're just some attorney who found this while he was doing research for an article. Well, the Trademark Modernization Act changed that. And it remains to see whether this is for better or worse, but anyone can file a petition for expungement or reexamination, because it is not limited by people who believe that they will actively be harmed. It could be anyone. And so what you can do is you file this and say, hey, I did an investigation and I found this. Here's my evidence. You present that not to the other side, but to the Patent and Trademark Office, to an office within the petitions office, and say, here's the investigation I did. I made out a prima facie case, and we won't get into the details of all the kind of things of what exactly is a prima facie case for infringement or for non-use, not infringement. But you essentially provide this evidence to the Patent and Trademark Office, pay a fee. It's $400 per class. And then the USPTO decides, did I provide them enough information? If they say yes, then they go to the trademark registrant and say, you need to prove to us that you were actually selling these. You need to submit additional items to show that these were in use when you said they were. And so it takes the kind of litigation out of the picture. It's not this unpredictable thing of me filing a complaint and then them responding, and then suddenly, $10,000-$20,000 later, we're deep in litigation. It is something that is solely in the hands of the U.S. Patent and Trademark Office. And once the petition is filed, I, as the petitioner, have no problems with when it comes to, like, I don't have to do anything else. It is now a procedure that's in place that I'm completely a part of. So I filed it. I have the distinction of being the first person to file a petition for expungement. And so I was able to get that in, and it was really nice to be able to get that after how much kind of experience I had during the creation of these. To be able to be one of the first people to file them was very exciting for a trademark nerd as myself. But and so I will know firsthand, and anyone who follows me on LinkedIn or social media can follow along on this journey, because I don't have attorney-client privilege with anyone. I don't have standing to bring this. I couldn't bring a petition to cancel this app registration even if I wanted to, because I don't have any other interest in this. So I think it's a unique thing for someone to be in, that where I'm willing and able to talk about it. And yeah, I'm looking forward to kind of seeing how it progresses, because I've submitted it and it has not been reviewed yet by the petitions office. So that's going to be the next step, is to see what they say about the petition that I filed.
And then they would give the other person like 3 months or so to.
Right, exactly.
So it might take a while, but
yeah. And I think ultimately what we could do before, if I had a client who was doing this, is file a petition to cancel with the Trademark Trial and Appeal Board. And that is at least $600, and because $600 per class just for the filing fee, in addition to attorney's fees, in addition to the uncertainty that comes with bringing a litigation. That when you bring litigation, you never know if the other person's going to come back swinging, or suddenly get involved in a situation that's cost way more and outside of the scope that you thought it would. And so I think this proceeding has the opportunity to streamline that, and to give people who want to go after these applications or registrations, but maybe they're not even far enough along in the process of selecting their mark, and they're trying to weed out some really good trademarks. They say, okay, I love this name, but there's this applicant who filed for 15 different things that have nothing to do with each other. I want to get rid of this. Maybe they will be able to use this to clear the way for their own trademark application, even if they're not even using it yet. So I think it has a lot of really good potential. I think that the other side of the unknown is, what happens if you get one of these? Because inevitably there's going to be situations where trademark owners are now going to have to deal with administrative procedures that they did not think that they'd have to deal with. And this is brand new. If you ignore them, it will delete everything automatically. You'll go into default, or not default, it'll just be deleted from your registration, or the entire registration will be deleted. So I think that trademark registrants need to be aware of this, and they need to be aware of this early on, especially when it comes to foreign applicants who are filing in the US. Because that's something that if they do what they do in Europe, if they do what they do in China, and they try to apply the same concepts to the US, they are likely going to run into problems with either the PTO examining process, or even if they're able to get it registered, one of these expungement proceedings, I think, is going to be a problem for a lot of foreign applicants who don't work with an attorney who is aware of these kind of issues before they even file in the first place.
Interesting, because they would be, they're not tracking it. People outside are just not keeping track of what's happening here now.
Right. Yeah. And it is something that it's very easy to file I wouldn't say easy, but there is a form and you fill it out. Foreign applicants do need to use a US attorney, but a lot of kind of trademark dabbling attorneys that maybe don't pay as close attention to this will just file whatever the client tells them. And my joke is I've got a 7-year-old, and there's a book called Don't Let Pigeon Drive the Bus. I said, don't let the client drive the bus. You got to be driving the bus, because if you take the client's information and just apply for it and say, all right, let's just stick it all in there, see what happens, I think that is a mistake. And it's going to affect a lot of how even trademark attorneys who do this all the time, it affects how we interact with clients. Because I've been doing this for a long time. I tell clients, don't apply for things that you aren't planning to use. Don't go through that elevated risk for something that's not worth it, because you're going to get into problems that you didn't foresee and that we could have avoided. But a lot of clients don't want to hear that. They want to hear, oh yeah, just my last attorney just applied for what I told them to apply for. And yeah, I think that takes a lot of extra effort and kind of trust in their attorney to say, no, I think that we should look at this again. And what the problem is that a lot of foreign applicants will apply for things that they don't plan to use, or that they're not using, with this idea of like, oh, I'll just get as much coverage as possible. But that's not how the US trademark system works. It's based on this idea of use in commerce. And there's some exceptions here and there, but mostly it is this idea that you're applying for things and you're registering a trademark for things that should be in use. And if you're not, then that's what these kind of proceedings are looking to address. You're taking up space that could be used by a new up and coming business that's going to increase the economy and are going to really use this trademark in a way that will be good for the brand. And you're stopping them from being able to do that by applying for an overly broad registration that you should not have been entitled to in the first place. And the PTO doesn't have the resources. And I think that's the biggest thing here, is that they don't have the resources to look at every single specimen and say, is this real? Is this fake? And then go item by item through a trademark application and say, all right, you have to prove every one of these. That will be, it'll be 4 years till you get your trademark reviewed. It's just impossible. They're giving the tools now to the stakeholders, to the trademark applicants and the attorneys in order to do that. And that's what expungement and reexamination is. They're kind of giving these tools to help police the register and to help get rid of that deadwood that's on there. And with them still doing their job and trying to do the best they can, but now also we have a tool to use as well.
So I have a question for you, because I seem to remember reading a while back about patent wars in Silicon Valley and whatnot, right? And so I'm wondering, what's the dark side of this? Is there a way this can be weaponized or something?
Right. And that's a big concern that people have, is this idea that if I wanted to, if someone is already submitting false specimens, if someone is using Photoshop to put a tag on a rug, in my case, that's what the specimen showed, then what's to say that those same people are not just going to make up a report and submit it to the government, or some kind of bad actor is going to say, I want to cause as much problems for this one company as possible. I'm going to file a bunch of these petitions and I'm just going to make their lives miserable. And I think that's probably unlikely, because the PTO put some safeguards in place. But there is a situation, I think, that there's going to be loss of rights. Maybe someone didn't update their email address. They didn't update their address. They had no idea they even got one of these expungements to begin with. And that's their responsibility to keep that up. That's why you should hire an attorney who's going to keep up with that. But there are situations where I can see a loss of rights where someone should have been entitled to it and just simply didn't have the funds to pay an attorney or didn't know what to do. And now suddenly they're in a position where they have less rights than they used to, or perhaps no federal trademark registration at all. And I think that that's where I see the biggest kind of unknown of this is that going to happen? Is this going to be so widespread that it'll be effective? Or is it just going to be something that is just another tool that may or may not have some use, but ultimately, it is not worth the time and effort versus just the old way of doing it and filing litigation?
Thank you, Eric. I think that's all the time we have today, but I wanted to ask you before we go, where could people go to learn more?
Yeah, the USPTO website has a really kind of great landing page when it comes to trademark expungement and reexamination. And I think that if you do just look up USPTO expungement, it'll come up, but also we can provide a link as well.
Fantastic. And it sounds like your LinkedIn page as well. So
follow me on LinkedIn to join me on this journey. I am always posting things about trademarks, and I think this will be one that I will very broadly publicize, which is something rare. I don't get to do much. So follow me on there too. And you can kind of see what a proceeding looks like, and I'll make sure to add some tips and tricks along the way.
Well, thank you for joining us today.
Thanks, Federico.
This episode of Brief Encounters was brought to you in part by our sponsors LawPay and MyCase. Find out how these solutions can work for you by visiting lawpay.com and mycase.com. For more information, check out the description of this episode.